So I want to talk about wills, a little bit more about wills. I want you to understand better about why I might recommend for you a will rather than a revocable living trust. Because ELG Estate Planning primarily practices in the state of Washington. We do also practice in North Idaho, but especially because we're in the state of Washington, if you want to protect assets for your surviving spouse when you're gone against long-term care costs, you can't do that through a revocable living trust. The only way you can do that is through a will. A will means it must be probated. So in order to protect assets for your spouse when you're gone, it needs to be done through a will. I often will hear clients say, but I don't want to probate. Totally understandable. It's another legal process. Anytime you're working with a lawyer, you will be paying legal fees. And lawyers will charge a much higher hourly rate than probably what you're used to seeing. Lawyers will charge for their services. You know what? And if they don't, unless it's through, some sort of public benefit situation, you might want to ask yourself, why is this so cheap? What am I getting? If you're going to get a $500 will, that might end up costing you half your estate. Seriously, that can happen. Let me explain why. Let's say you're a couple, and let's say you've got $500,000. Half of that's in your house and half of it is in retirement and bank accounts, So you've got $500,000 and you think, our estate is really simple. We don't need anything but a simple will. And so you find the cheapest lawyer and they give you a $500 will. And on your death, what happens is, hopefully you can avoid probate. There's ways to do it. Maybe you can, maybe you can't, but everything ends up being the surviving spouses. So $500,000 is now owned by the surviving spouse. Well, what happens if during your lifetime, you or your spouse start to need long-term care? The probability is that one of you will need long-term care, not a possibility, probability. And long-term care is very expensive. $8,500 for an adult family home or assisted living, $12,000 to $14,000 for a skilled nursing. It's expensive. It won't take very long before all the assets are gone. So with a simple will, the surviving spouse inherits everything outright, no protection. What I think is a better outcome would be that this will included an asset protection supplemental needs trust in it, so that at a minimum, we can protect half the estate. The deceased spouse's half gets put into a trust for the surviving spouse. Assets in that trust will not be counted by Medicaid, will not interfere with government benefits eligibility. So let's say that the situation with a couple in the house, one of them, that's $500,000 total estate, first spouse dies. That spouse who died, they have a will with an asset protection trust. And through the probate process, the surviving spouse now has a trust. Perhaps we put in that trust the money, $250,000, and the surviving spouse owns the house outright. That surviving spouse needs long-term care. They are immediately eligible. They can apply for Medicaid, and Medicaid will take care of them. That $250,000 in the trust doesn't count. The $250,000 for the house doesn't count. It's an exempt resource. So we can protect a lot of money by using an asset protection trust. So that's why I say sometimes that $500 will end up costing the couple half their estate, potentially hundreds of thousands of dollars. There's other ways to protect more than just half the assets, and that's probably a subject for a different discussion. So wills can include with them really powerful and important protection of assets for your beneficiaries, not just your spouse, but a special needs child, or for example, maybe you have, a child, a beneficiary, an adult who has lifestyle issues, or they're going to looking at a divorce, or all sorts of real life problems that many people deal with, you can put in your will trust to protect your beneficiary. That's one of the reasons, especially in Washington, that we will recommend wills over revocable living trusts many times.